All right. The court has had a chance to consider and review the motion made by the defense. I think, as you're aware, to succeed on a sufficiency of the evidence claim, the defendant must show that, viewing the evidence in the light most favorable to the state, no rational trier of fact could find guilt beyond a reasonable doubt. All reasonable inferences derived from the evidence are also viewed in the light most favorable to the state when deciding a motion to dismiss. As I hear defendant's arguments with regard to the 2 second-degree assault charges, defense contends that there is no evidence that the defendant was aware of the risk of causing respiratory distress or hypothermia. I think the jury can find, upon the evidence and considering reasonable inferences from the evidence, that she was aware of the risk of bodily injury, to include respiratory distress and hypothermia, when you consider all of the facts and circumstances with regard to the case. And again, that is viewing the light in the evidence most favorable to the state. The defendant's arguments that there's no injury, again, with regard to the second-degree assault charges, these charge bodily injury for which there is no statutory definition, based on the evidence that was presented by the nurse, the doctor, and those on the scene. The court does not find that that's a basis for the motion to dismiss either. On the reckless conduct charge, the question of defendant argues that she could not have consciously disregarded the risk because she didn't know that there was a risk. Again, there's differing testimony on that, but there is, given the testimony of the medical personnel, and that she indicated at some point that but there was at least testimony that at some point she indicated that the baby was crying. The court doesn't accept the argument that taking the evidence in the light most favorable to the state, no rational trier of fact could find that she consciously disregarded the risk. Additionally, with regard to serious bodily injury, given the testimony of the doctor and the nurse regarding the physical condition of the baby when it arrived at the hospital and on the scene, it would that there is a conscious disregard that she let me just skip the language of that she engaged in conduct that placed another in danger of serious bodily injury. The court finds that, based on the evidence presented, that charge can go forward also. On the falsifying physical evidence charge, the physical evidence, the defendant argues that the concealing the location of the baby, the location is not physical evidence, but I do read that charge as indicating that the effort was to conceal the location of the baby as the physical evidence, not the physical evidence of the location itself. And so for that reason, the motion to dismiss on that charge is denied as well. And similarly, on the endangering charge, again, the question was whether or not, or the issue that the defense raises, whether or not she acted knowingly, and again, that is a question for the jury, given that there is some conflicting evidence about that issue, but there's sufficient evidence to allow the state to go forward. So for those reasons, the motion to dismiss these charges is denied. The court does...
May I just ask one question?
Yes.
I think you said that for the second-degree assaults that she was aware of the risk of injury, which is not, she has to cause the injury.
Yes, I'm sorry, that she recklessly caused injury manifesting extreme indifference to the value of human life. I thought I said that defendant was, you argued that the defendant was not aware of the risk.
Well, for the other charge, I mean, consciously disregarded a risk, yes, yeah. I guess I was confused if you were saying the risk of bodily injury or you were talking about the mental state. not the risk of bodily injury.
So I took your argument to mean that she, hold on a second. Sorry, I'm just looking at my notes. So that there was no conscious disregard. I thought, I took your argument to suggest that there was no, that those charges could not go forward because there was no conscious disregard of the risk under the
Right.
recklessly standard.
No, I understand that.
Okay,
I just,
okay.
like, I think it's just the way you said it was that she was aware of the risk of bodily injury. Or she has to be found to have caused the bodily injury.
Yes, but your argument was as to the conscious disregard.
Yeah,
That she
I
acted
argued the
recklessly.
causation too.
Yes.
Yeah.
Okay. So, as I said, I do find that there is sufficient evidence to allow the state to go forward with regard to the issue of no conscious disregard of the risk.
Okay, I understand. I just wanted to make sure I was clear that you
Okay.
weren't saying that the indictment is worded the risk of bodily injury, because
Okay.
that's not
No,
what it
no.
is. She has to have caused the bodily injury.
Yes.
Okay.
The conscious disregard of the risk. Okay, so having said that, it's my understanding, Counsel, why don't you approach regarding where we are? Please be seated. All right, ladies and gentlemen, as you know, the state has rested. That means they've concluded the testimony that they are going to enter in their case in chief. Sometimes testimony moves more quickly than we anticipate, and that happened today. So what we're going to do is this. I'm going to release you for the day. We're going to come back on Wednesday morning, at which time it will be the defense has no obligation to present any evidence whatsoever, but they may do so if they wish to do so. After the defense, if they put in any testimony, after that it would be time for closing arguments and final instructions and then jury deliberations. So we anticipate that this case may, we may get through that on Wednesday, or it may go into Thursday. But we do anticipate, I mean, you know, we never know how long deliberations are going to last, so we always want you to plan accordingly. But we do anticipate that the testimony will likely conclude on Wednesday. We may get to closings or instructions, but it can also go into Thursday, and then deliberations would last as long as the deliberating jurors need. So I'm going to release you today. I'm going to remind you once again not to talk about the case, not with each other or with anybody else. Make sure that you are avoiding any media coverage of the case, whether that's online, newspapers, television. Please make sure that you are avoiding any coverage of this case, should there be any. Don't do any independent research. Don't look up any names on social media or anywhere else. You have to decide this case based exclusively on the evidence that's presented at trial and the law as the court will give it to you in the court's instructions. All right? So thank you. I hope you all enjoy the rest of your afternoon. I'm sorry it was a little bit of an unanticipated break that we're having this afternoon. So thank you for your attention today. Ladies and gentlemen, we will see you Wednesday morning at 9:45. Wednesday morning, 9:45. Thank you, everybody.
All right.
Thank you. All right, counsel, you want to approach for a minute regarding preliminaries? All right, everyone, we will resume testimony on Wednesday morning. And if you communicate with the clerk, she may have that draft instruction for you by tomorrow morning.
Okay.
Okay, all right. All rise.